Here we have a great question about prenups. This comes up pretty often in various forums in Illinois. So here's the question. Wife and I decided to divorce, married since 2013. We have a prenup in place where accounts, debt, retirement funds are our own and untouchable. I bought the house in 2012, but in the prenup, she receives 33% of equity. We now have two children who are not mentioned in the prenup. Her lawyer told her that the prenup would be null and void as we now have children. Also, Illinois is apparently a 70-30 or 60-40 state with regards to child custody, not 50-50. Is the prenup void now? We split child care 50-50, but I pay all health care. I've heard Illinois is a state that favors the mother always. Advice? I'm planning on meeting with a lawyer this week, the one who did our prenup, but he also did her first marriage divorce. He couldn't represent her, could he? As that could be a conflict of interest. Well, there's a lot to unpack here. There's what I see three major issues. First, a question about whether the prenup is still valid. So if it's a typical prenup, the answer is yes. Just because you have children doesn't invalidate a prenup. I don't know why the lawyer is telling your wife that just having kids is invalidating the prenup, unless your prenup has a term in it that says it's void if you have children. I've never seen that before. Doesn't mean it couldn't be done. Off the top of my head, I think it would be enforceable to have that type of term as a termination provision in the agreement. But I've never seen that done before. That would be highly unusual. What's the point? Most people expect to have children. If just having children would invalidate a prenup, that doesn't make a lot of sense. So read the prenup. That's the document that determines everything. And if you don't see any provision related to children, you're fine. It won't terminate just because you have kids. I think your wife's misunderstanding. The thing that she might be thinking, and the lawyer might have told her, is that prenups don't decide anything related to children. That is, custody, visitation, allocation of child support payments, payment of expenses for children, payment of college expenses. Those things by law cannot be determined in a premarital agreement or prenup. So what she may have heard, people hear what they want to hear. What she probably was told by the lawyer is none of the stuff in the prenup deals with the kids, so that all has to be determined. The prenup only deals with assets. Now, you didn't mention anything about maintenance or alimony. A lot of prenups discuss what happens with alimony or maintenance. I don't know about your agreement. And you do discuss what happens with your property. Each keeps your own, and then you say she gets a third of the equity of the marital home. So you got to look at the prenup for reference and talk to a qualified Illinois attorney who handles divorce, especially, to get detailed information on that. Next, 70-30 or 60-40 state, Illinois. Okay. Illinois does not yet have a law providing for 50-50 parenting time automatically or by default, as several other states do. And I've talked about this in some other videos, and I've actually discussed it in podcasts related to my book, I Just Want This Done, How Smart, Successful People Get Divorced Without Losing Their Kids, Money, and Minds. Anyway, in my book, I talk about states that have 50-50 parenting. Illinois does not yet have that. There has been a push in the past for that type of law. It is not passed as of yet. Your question is it a 70-30, 60-40, 50-50 state? Well, we're talking about, there are two different issues here. One is custody, or what we call allocation of parental responsibility. And that's the legal decision-making for the kids, which is separate and apart from the parenting time or visitation. That is the time you spend with the kids. What you're really asking is, they're really the two separate issues. I can tell you that Illinois leans toward joint custody or joint allocation of parental responsibility. That is shared decision-making equally between the parents, unless there's a very unusual circumstance. So that's part one. That is separate and apart from who gets parenting time. And I can tell you that in Illinois, the preference is leaning more and more toward equal time, and it also depends on your jurisdiction. In Chicago, Cook County, and the outlying collar counties, the trend is liberalizing towards more time for fathers, or let's say the parent who has traditionally spent less time raising the children. Downstate, in more conservative counties, you may find a more old school approach where people sort of think the default is the parent who spent less time raising the children, the dad typically, should get a more traditional parenting schedule, the every other weekend, couple nights a week kind of thing. We've seen in our in the lifetime of our law firm since 1994, a fairly significant trend towards more time for dads. And now we typically tell people to expect in the Cook and the Collar counties more like 60-40 time, getting closer to 50-50. And some of that depends on the judge. Some of that depends on the pre-existing circumstances. So how much time have you spent parenting the children thus far? What are the job roles of both people? What are their schedules? The court's much more willing to consider much closer to equal time, if not equal time, for both parents. So the trend is positive. If you are the parent who typically spent less time raising the children, the trend is more and more positive. So I don't want to say no on that. So much depends on the particular jurisdiction and judge and your circumstances. But I wouldn't say, so I'd say you're looking at joint custody typically, or shared allocation of parental responsibility, unless it's a very unusual circumstance. And then parenting time, you can expect much more liberal parenting time than in the past, approaching 50-50, but it is not legally the default in Illinois. Next, and child support just has to do with your relative incomes, both of your incomes in a formula and the number of children, and that cranks out the support number. It's much less than it used to be. 2017, the child support law changed dramatically in Illinois. The support amounts generally dropped quite a bit for the payor to pay the payee, and both incomes now are taken into account, whereas before that was not the case. All right, your last question here is meeting with a lawyer. This is a conflict of interest question or ethics question, really. So in this case, you're saying you're going to meet with a lawyer who did the prenup, and they represented your current wife in her previous divorce. That is an interesting circumstance, a little unusual. And you say, well, you don't think he can represent her. Actually, I'd be thinking the other way around. If he represented your soon-to-be ex, your current wife, in her previous divorce, he may think he has a potential conflict of interest representing you. And also, I'm not sure which person he represented in the preparation of the prenup. He had to represent only one of you, and that's significant as well. Chances are this lawyer won't want to represent either of you, I'm betting, because he was involved in the prenup, or whoever he represented in drafting the prenup, I'm guessing was your wife. He may say, well, that's the person he wants to represent in the divorce case. So I'm not sure why the lawyer's meeting with you, except to talk about what the prenup says. If I was that lawyer, I would tread very lightly, and I would be concerned about a potential conflict of interest. I don't think there's a direct conflict of interest because he has never represented you versus her in the divorce or in a case. But still, it's a sticky wicket that he's represented probably her in preparing the prenup, but you didn't tell us if it was you or her. So there is a potential conflict here. So I would say consult with an attorney, and you may want to add more, give us more feedback, and we can answer those questions. But I hope this gives you a generally overall good answer for your question. So to review, a prenup shouldn't be invalidated related to children, except the issues related to kids are open items. Number two, this really isn't it's a shared custody, joint custody state, but it is not a default 50-50 state for parenting time. Excuse me, parenting time. And finally, conflict of interest, I think, cuts actually against you, not her, but I don't know all the facts. Hope that helps. Thank you. Like, share, and subscribe for more.